Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. And today we have our annual joint podcast with Tiffany Lashmet's podcast talking about the top issues in 2020. So I will turn it over to myself and Tiffany.
Well, Paul, we're back again.
Yes, we are, Tiffany. It's that time of year again, isn't it?
That's right. I feel like this has become one of our favorite holiday traditions is our year-end joint podcast to recap ag law over the last year.
I mean, it's like an end-of-year ritual at this point. We have to figure out what the top issues are, because at some point we're both going to be called upon to write this probably months ago to go out.
Exactly.
At the first of the year.
Yeah, I like about this better is that we actually do get to wait till the end of the year to record it. Versus, like you say, a lot of the articles were due at the 1st of November, and inevitably something blows up and changes everything the week after I submit the article.
Or September. I mean, I think I had one due in September. So, yeah, it's really nice that we can actually have time to reflect and see what happened in the year and just come out and go well, we don't know what's going to happen here. And then something happens and we just feel to be idiots because we can't. Our fortune telling needs to pick up, Tiffany. Our fortune telling needs to pick up. We need side hustles as fortune tellers.
For sure.
That's what we've learned out of the past years, how many years we've done this.
I know. Well, I'll tell you one thing we've learned is that the issues don't change much, because I looked back and a lot of the issues we had last year are still on our list today.
And we should probably take bets as to how long they'll stick on the list, but that would probably just be sad on our part.
Well, several of them I don't think are going anywhere. So,
no.
All right, well, let's go ahead and give everybody our list and kind of the news of what happened in 2020. Paul, let's kick things off. I think for both of us, it was a pretty easy number one issue, and that's Dicamba.
Yeah, we had a lot of stuff happen in Dicamba this year. And looking at the list we have together, I'm going to go with the first one kind of first, or the second one first, because it really did happen first. We had this loss. We had a trial. It was probably the last trial, as I tell producers here, that was held in that federal district court before COVID shut everything down.
Right.
We had a jury trial involving a Missouri peach farmer who had Dicamba Drift. He sued Bayer and I believe one of the other companies, and that ended up in a large multi-million-dollar verdict. And if I can get my notes up, because I had it up on the other screen and you guys can just let me keep talking. We ended up with $15 million in actual damages and $250 million in punitive damages in that case. At the same time, we had a class action going on. This was not a part of that class action. This was a separate case, but the claims were pretty much the same in both. And that has led to a huge settlement coming out of Bayer. We don't have the Roundup settlement on the list because that's still kind of in flux, it seems like right now. But at the same time, we announced this Dicamba Drift. And for those that are unfamiliar with the Dicamba Drift issue or haven't listened to us in the past, we had this issue when the dicamba-based herbicides came on the market and the technology related to the seeds that were resistant to these new products come on the market. We had a lot of drift issues across basically the South, some in the Midwest, a little bit in the Mid-Atlantic, but not much. And the issue at fault was basically, did this new dicamba product in the end volatilize when it hit and was applied and then drift later like older products had done? That had sort of been the issue there. And this led to this $400 million settlement by Bayer earlier in the year. So we still don't have a lot of details on that. I haven't seen any. I don't know if you have.
I haven't, no. And just by way of background, because this may matter a little bit when we look at some of the additional issues in the Ninth Circuit case, the seeds we're talking about are soybean and cotton seeds that have been modified to withstand the application of dicamba. Right. So this over-the-top application to these row crops was different than dicamba use before. The other thing is, and this was a big deal in several of these drift lawsuits, including the major class action, is the seeds themselves were released like a year before the pesticide was approved for use. That was a big part of those claims too.
Yeah, that is a big part because and some of this we don't know if it actually was that dicamba or somebody was misapplying an older product that wasn't approved for over the top. So there are some issues there that came up, and we probably have both spent too much time talking about the lawsuits, pesticide drift issues, just because of this case and these products. And it looks like it's getting settled. We
Right.
don't know who's all involved in the settlement. We don't know how it's going to be structured yet. We do know it's probably going to be for about 2015 to 2020, I believe is what I remember seeing. And it's going to be based on yield damage, probably based off you have drift damage. So you're going to have to come in with records showing that, but we don't know exactly how any of that's going to apply. We don't know if there's a nationwide class like there was in the Syngenta lawsuit, where states that didn't have class actions got money out of it. So we don't know how any of this is going to be distributed at this point. So I guess we'll be talking about this next year when we get all the details.
That's right. That's right.
Figure out who's getting what out of this settlement. The one thing to point out is the case that did go to trial and was at jury verdict. Last I have looked, it is still under appeal. Bayer now is still appealing that and is still actively pursuing that one to, I guess, get the damages reduced in the punitive damages phase, which we'll talk more about punitive damages when we get to Right to Farm this year.
That's right. That's right. Okay. So the other big issue that I think everybody is really aware of if you're involved in ag is the Ninth Circuit decision where they vacated the federal label for these dicamba products we're talking about. And this happened in the spring, right as kind of everybody, at least in Texas, would have been applying these products to their cotton. And so it was a big deal.
Yeah. So, yeah, like you said, we had the Ninth Circuit come in and look at how EPA had registered these dicamba products more recently. I forget what year they were more recently. I believe it was 2018 was when that happened, but don't quote me on that. I can't remember exactly all of that. But coming in, the major problems in the end, looking at the Ninth Circuit, they found these three risks. Like EPA had not taken into account the amount of planted acreage with these dicamba resistant seeds. Had issues. We had these new dicamba soybeans and cotton that had come on the market. We also had issues where EPA had not really looked at the complaints of dicamba damage. Would they be under or over reported to take that into consideration? And then they didn't estimate the damage that would be caused by these over-the-top applications. The over-the-top applications were the new applications that were going on with cotton and soybeans. So EPA didn't take that into account. And that was enough in the Ninth Circuit's eyes to do a vacatur of that registration and move us back to not having these products on the market. And then EPA had to cancel that registration, which I think, as we both learned, is actually the only method EPA has to get a product off the market. If not, they just have this stuff setting and no one can use it. So they have to figure out a way to get rid of it so it can be disposed of. So that was about the 1st of June when that happened, if I remember correctly.
Yeah. And they went ahead and let folks apply it. I think it was to the end of July.
Yes, till the last part of July.
Yeah.
But you couldn't buy anymore. You could only use what you had bought prior to the court's ruling. Anything that had not been sold had to be returned, and anything that was bought could actually be used. So if you didn't have enough bought, you were not in a good place at that point, probably.
That's right. So at that point, we didn't have, like you said, at least 3 of these products were off the market, couldn't be used. Now, they were coming up, the expiration on their registration was coming up at the end of the year anyway. Yeah. And so that's been kind of the most recent news is the EPA did go ahead and approve these products for at least 3 of them for 2021, but they've added in some new labeling restrictions.
Yes, they have. Yeah, there's going to be some new pH buffering agents required in the mixed tank to hopefully reduce some of the volatility that happens with this product. More downwind buffers, depending on if there's an endangered species listed that's in that area. We've got now national cutoff dates for this product, and the label is apparently going to be much more simplified so growers can actually understand what they are supposed to be doing when they apply this product, and hopefully end some of the drift issues that we've been experiencing. And now the product is labeled till 2025. I remember
Right.
correctly.
Now, that said, right, there are lawsuits that have been filed challenging this, filed by the Soybean Association and Plains Cotton Growers here in Texas. And that basically says that the restrictions on the label are kind of too strict, right? They don't like that nationwide cutoff or the additional buffer. So lots of lawsuits going on around that. One other thing I would note that came out of that label, and I think it was just a footnote maybe in the new registration, is that states cannot use Section 24C of the FIFRA to make additional requirements, like additional more strict rules in one state, right? Instead, they can't use that anymore. So they're going to have to go through 24A, which is a more complicated process to get that done. I read an article today that said some states are looking at doing that and working on that now to have different cutoffs. Arkansas is one. I think Illinois was another. So there still may be some different state requirements. It's just going to be harder for those to be done procedurally.
Yeah, that makes sense because, that's a good point on the footnote. That will change that to where we'll probably have some at least national. But yeah, my guess would be Arkansas is really going to go strict on this because they had a lot of the issues early on. That's kind of where ground zero was early on.
Yeah, that's right.
But I don't know if we can say, to me, the main thing I think we recognize out of this, because we've seen it with 2,4-D too, in the Enlist Duo product as well. We're seeing a lot of the same claims coming up for these new products once they get registered. It's almost always an Endangered Species Act issue. There's almost always some other claims they didn't follow FIFRA.
Yeah, or the APA. Yeah.
The APA properly. So I expect that with any new product that comes on the market, we're going to see these challenges, and they're almost always going to be located in one federal court going forward, it seems like.
Yeah, I think that's right.
Yeah.
So stay tuned is what we're saying.
Yeah, we'll be back next year to talk about this as well.
That's right.
That's the way it goes. So now on to the law I really don't like to touch and just prefer to admit it doesn't exist most days, but I know I have to deal with it. But Tiffany loves to deal with it. Why don't you tell us what's been going on with the Clean Water Act? And specifically, I guess to start with, what are we dealing with this new navigable waters protection rule that's replaced the old waters of the U.S. rule? And where do we stand? What's going on with that?
Sure. Yeah, the Clean Water Act is another topic that I think has been on the list every year we've done one of these reviews. And just by way of background, right, the Clean Water Act is a federal act that requires if you're going to do certain things on your property and your property is deemed a water of the United States, you've got to get some federal permits to take certain actions. And the problem is when this was passed back in the 70s, they didn't define what waters of the United States meant, right? And so, like Paul said, we had the 2015 definition that was promulgated by the Obama administration. Flood of lawsuits came in surrounding that. This year, the Trump administration has issued their own rule, and they have called it the Navigable Waters Protection Rule. And it's the Trump administration attempt at defining waters of the United States. And so essentially what this rule does is it provides that there are 4 categories of jurisdictional waters. The first one is, this is one that's not controversial. This is included in kind of every definition we've had ever. The territorial seas and waters that are currently used, previously used, or may be susceptible to interstate or foreign commerce. The second category is tributaries. The third category is lakes, ponds, and impoundments of jurisdictional waters. And then we have adjacent wetlands. And so if you look at the definitions of things like tributaries and adjacent wetlands, this rule is written much more narrowly than the Obama rule was in 2015. So this was passed and the ink basically wasn't dry before, again, we have lawsuits flooding into courts around the country. So we've got lawsuits kind of on both sides, right? Some sides are challenging it, saying the scope of this rule is just too broad. Even though it's narrower than Obama, there have been some suits that say it's still too broad. We're going to narrow it up even further. I think the majority of lawsuits are on the flip side of that, saying, look, this rule is just too narrow. It's not taking into account some of the effects this could have. It's not right under the Clean Water Act. And there's been some legal challenges there as well. then, of course, you throw the wrinkle in of a new administration coming in January. I don't know what happens then, right? I mean, we still have pending lawsuits challenging the Obama rule that was, vacated by this EPA. Now we have the Navigable Waters Protection Rule and all of these lawsuits. I don't know what happens when the Biden administration comes in. They may, revoke this and make a new rule. They could go back to the 2015 rule. We'll just have to see.
Yeah, it seems like it's something we're going to be talking about again next year and maybe the year after.
Yeah.
Seems like we're just going to talk about it forever until.
Well, and truthfully, right, like that's a really frustrating thing if you're like a landowner or a producer or a developer. The idea that we can't get on the same page about what this, statute and the permit scheme means, that's really frustrating from a practical standpoint.
Yeah, especially if you're a producer with wetlands and you want to take new land into the farm.
Yep.
And you don't know, am I going to end up needing to get a permit, or am I going to get hammered with recapture at some point because I did something wrong?
Right.
Yeah, I can see how that would be. I can see how I would get frustrated with that.
Yeah, for sure.
So I guess that's really all we can say on the new rule and where we stand with that. So I guess now we can go into the decision that everyone was waiting for that we probably talked about last year. I didn't go back and look to see if we talked about this last year. But, Maui County, and you actually got to go to those hearings for the oral arguments for that before the Supreme Court, and the opinion came out.
Yeah. Yeah.
Year.
So the Maui County case, like Paul said, we happen to be in DC. Kind of all the ag lawyers around the country happened to be there the day that this was being argued, because we had our annual American Ag Law Association conference there, and a handful of us were able to go and listen to the arguments, which was fascinating. And the opinion came out this year, and I think it was kind of what we all expected after hearing the arguments. But essentially, the background in that case is, under the Clean Water Act, if you're going to discharge a pollutant into a water of the United States, you've got to get a permit to do that. But the question has arisen, what does it mean by discharge into a water of the United States? Does it have to be a direct discharge, or could it be an indirect discharge that ends up in the water of the U.S.? So the facts in Maui County are that the county had drilled some disposal wells or injection wells where they disposed of effluent. And the wells obviously disposed of this into the groundwater, but then because it was so close to the Pacific Ocean, there was dye tests done that showed it ended up in the Pacific Ocean, right? And so obviously the pollutant in the Pacific Ocean looks like a pollutant in the water of the United States, but it wasn't discharged into the ocean, right? There wasn't like a pipe that sent it into the ocean. That clearly would need a permit. Here it was discharged into the groundwater, right? And groundwater is not a water of the United States. And so this was what the court was sort of trying to deal with is, well, how do we make this rule, right? Do we say that it has to be a direct discharge, like pipe into the ocean? Or do we say that permits can be required if it's an indirect discharge and it just ends up in the ocean? And they really struggled with that, right? Because there were kind of problems both ways. If you said it had to be a direct discharge, one of the justices said, well, so what if somebody just cuts the pipe off, 50 feet from the river, and all of a sudden they don't have to have a permit? It'll give an end run around the Clean Water Act. On the other hand, the idea of, anything that ends up in a water of the U.S., Chief Justice Roberts actually said, with science now they could trace anything. What if they can find out that somebody in, Colorado flushed their toilet and that pollutant ended up in the river? And so there was a lot of back and forth. What ended up happening was an opinion written by Justice Breyer, where the court basically said that a permit is required for a direct discharge or anything that is the functional equivalent of a direct discharge. Now, functional equivalent is one of those tests that I like to call mushy, right? Because I don't think we really know what that means. And the court listed like 7 different factors that can be considered. That's not a be-all, end-all list, but it's just some things you might consider, including the distance from the navigable water, the time it took for that pollutant to reach the water of the U.S., et cetera. What I think it really left us with was this new standard, and now really lower courts are going to have to try and figure out how to apply that, and just see how they end up defining functional equivalent.
I'm glad you can understand all of that and can clearly tell me what all that means, because
yeah, it's a fun issue. And it was really cool to go to that oral argument. That helped a lot too. So
I bet that would have been cool.
Yeah. All right. So Paul, let's shift gears now and look at one of your favorite topics, which is right to farm. I know we had two.
All our favorite topics, really.
It's high on the list. Yeah. I know there were kind of two different things that happened. I guess let's start with the Indiana case that sought review by the United States Supreme Court.
Yeah, you may have to help me with this, because this is how I think this case was being pled when it went to the Supreme Court. It was basically looking at it as a Fifth Amendment takings issue, that because of this law, we now because of the right to farm law and the nuisance created, we have a takings that's been created by the state government, and somebody should pay for this. Or am I oversimplifying it to a level that...
I mean, essentially, right, it was a constitutional challenge of the Indiana right to farm statute.
Yeah, and the background on the case is basically we had a hog farm that was built in an area, and if you go back and look at both the Court of Appeal, the Indiana Court of Appeals, and I believe the Indiana Supreme Court. I can't remember if the Indiana Supreme Court...
No, the Supreme Court didn't hear it.
That's right. They rejected it. So in the Court of Appeals, we look at it, and they look at it and they say the land is clearly zoned for industrial agriculture, or high intensive agriculture was, I believe, the exact wording that was used there. And we have this hog farm built. The area was clearly ag. These people had moved in while it was clearly ag. Nothing had changed the condition that we're going to get into in North Carolina here in a minute when we talk about those cases. And in the end, the Indiana Court of Appeals said right to farm applies. So there's no nuisance case. There's some other stuff we can talk about, how, the plaintiffs never challenged the permit at any point and clearly gave up any ability in that court's eyes to handle the issue. And the plaintiffs lost their ticket, and everybody wants to make a federal case out of something. They clearly tried to make a federal case out of this and petitioned the Supreme Court for to hear their case, looking at it as a takings case. And that was rejected by the Supreme Court here recently. So that issue is effectively dead. And I think from looking at this does provide some guidance maybe down the road that there may not be Fifth Amendment takings cases in some of these, but we may just not have had that challenge come up enough that we know that that's not going to happen. Because we know that's a deal in Iowa. That's an issue in Iowa all the time. So it's something
I think it's one of those things I kind of always tell people, don't read too much into the courts, the U.S. Supreme Court rejecting to hear a case. It doesn't necessarily mean that they agree with it or not. It just means they're not going to hear the case. So
yeah, clearly there's not enough there to show that this is a Fifth Amendment case. So Tiffany, we had another right to farm issue that we sort of have every year that comes up. We had, this North Carolina hog farm litigation that consistently is something I think we've talked about the past 3 years now, at least. We've had guests on our podcast to talk about it. So why don't you give us a little bit of background on the case and what we're looking at here?
Yeah. And like you say, this has been an ongoing issue. Both of us have done blogs and podcasts on it. But essentially what happened is that there were some nuisance lawsuits filed in North Carolina having to do with a number of different hog farms. The hog farms themselves weren't named as a defendant. What was named as Murphy Brown, which is a subsidiary of Smithfield Foods. And like I say, I think there were like 26 lawsuits and several hundred plaintiffs that filed these suits. And so there were trials on 4 or 5 of them. All of those resulted in verdicts in favor of the plaintiffs. And they were awarded both compensatory and punitive damages in each of those suits. And so they ended up taking one of those cases up on appeal, and they stayed the rest of the lawsuits until this appeal could be handled. And so this one case called Kinlaw Farms was appealed to the Fourth Circuit. A number of issues were raised. Paul, we'll let you get into the details of at least one of those in just a minute. But eventually what happened is the Fourth Circuit said They're going to affirm the verdict in the Kinlaw case as far as punitive damages and compensatory damages liability went. The one place that they reversed on that was they said that the jury improperly considered certain information and evidence in deciding the amount of punitive damages. So they basically said, yeah, jury could award punitive and compensatory damages, but you need to go back and retry on the amount of punitive damages. Mm-hmm. And so almost immediately after that opinion came out, the Smithfield's company announced that there was going to be a settlement. And so similar to what we talked about before, we don't know the amount or the details, but there's been a settlement announced that would apply to all of these nuisance cases in North Carolina. So now, Paul, I didn't want to get in the weeds there on that 144-page opinion, but why don't you tell us a little bit about how it did and did not address the Right to Farm Act?
Yeah. So if we look at it, yeah, you do say it's a 144-page tome on various issues, not just right to farm, the most being the punitive damages and some issues that are more what legal nerds care about than what the general public actually cares about, like how to qualify an expert for trial.
Right.
But if we look at the right to farm law, North Carolina changed the right to farm law in 2017 to make cases like this harder. They took away some of the ability to get these high damages by limiting damages to the diminution in value associated with it. That would really take away the incentive. And if we look at the opinion in it, the attorneys for the plaintiffs even point out this probably would not have allowed them to bring a lot of these lawsuits that they did end up bringing. Looking at that, the issue was, they didn't challenge it on appeal, the law that was in place when the judge made their decision. They challenged it based off this change in the law. And the court really did look at it. And this really is a true legal nerd issue. It's more on how can laws apply retroactively. In this case, the Fourth Circuit said this law cannot apply retroactively to these cases. There was some ability in North Carolina law, if I remember correctly, that you could pass a law that helped interpret the prior law better. That the court found did not happen here. It really was providing whole changes, taking away the ability to sue and limiting damages. So they said the right to farm law changes did not apply retroactively. We don't know how the Fourth Circuit would have handled the issue of the previous law, because that wasn't under appeal here. So
now, and the reason, that the right to farm defense, the original one, wasn't at issue or wasn't able to be raised in the cases that the judge decided it didn't apply. And that was because of a provision that said that it could only apply if there were a change of conditions around the property. Mm-hmm. That decision wasn't appealed. And I mean, I don't know why. I'm not on their legal team. Maybe it was because they've changed it and they have this new law. I don't know, but that wasn't part of the appeal.
And there were some North Carolina decisions that I think would have made that appeal harder for them to make and make it see that it wasn't. There were some case law, I think, that limited that. I haven't asked specifically why that was, but my guess is it was case law.
Right. I will also note that there is a lawsuit that's challenging the new or the amended North Carolina right to farm statute. That's in state court, and we're recording this on the 10th. I know they actually have a hearing today. So stay tuned to see, how that shakes out.
I'm sure we'll figure that out sometime early next year. They'll issue an opinion in that.
This is the gift that keeps on giving.
Right to farm will never go away.
Right.
So looking on, the final thing that we have to talk about, that we appear to talk about most years now too, the beef checkoff decision.
Yeah. So, this, again, ongoing litigation, but there was a lawsuit that was filed by RCAF up in Montana a couple of years ago, essentially challenging the beef checkoff program. And the defendant in the case was the Montana Beef Council. And so the way the checkoff works, right, is if you're going to sell cattle, you have a $1 a head assessment. And at least in Montana, and there's several other states that do this, 50 cents of that goes to the national checkoff organization, and the other 50 cents stays with the qualified state beef council in the state. And so this lawsuit was, RCAF argued that the beef checkoff program violated the First Amendment because it didn't agree with speech it was being forced to fund. In particular, it didn't like some of the advertisements from the Montana State Beef Council that were advertising for beef generally and not just for American beef. So they filed this lawsuit claiming that this violated their First Amendment rights. And we end up with a verdict this year where the court said, no, there's not a First Amendment violation here. And the reason is the court held this was actually government speech. And without getting way in the weeds on this, basically Montana and a number of these other state qualified beef councils, Texas included, entered into a memorandum of understanding with USDA. And basically the USDA has the power to approve or edit or is really involved in the process of coming up with the messages from the qualified state beef council. And they either approve or reject them before they ever go out. And so because of that oversight from USDA, the court said, this is government speech. There's different standards here. You haven't met the challenge. You haven't been able to present the evidence required to challenge government speech, and we're going to dismiss this case. Now, that was appealed. That decision has been appealed by RCAF. And meanwhile, RCAF has filed a second lawsuit against the USDA for these memorandums of understanding that were entered into with the various states, claiming that the MOUs violate certain rules, procedural issues, things like that. So again, we've got ongoing litigation there. Like I say, at least for now, that's been the decision out of Montana. We'll see what happens on appeal and on this new case probably next year.
Reach corn growers and other people that this could potentially reach down to as well.
Yeah, well, that's the thing, right? I mean, when you look at checkoff programs, all of them are a little bit different.
Yeah.
But some of this could be overarching and potentially apply to other checkoff programs. I know, and I haven't studied this super close, but I've heard folks say that the beef checkoff and the soybean checkoff are really pretty similar in how they're set up. So there certainly could be some overlap.
Yeah. So anything else we have to talk about? I think we've run through the list.
With that, yeah, that was kind of our list. Of course, we could be here for 3 days if we went through everything. Each of our states, I know, have had major issues. And so I guess if you're in Maryland, make sure you check out Paul's blog. If you're in Texas, check out mine for any of those kind of state-specific events that happened this year.
And next year, we'll have to figure out how to live stream this so everyone can see us go through this and figure out how we actually do this each year.
Yeah,
it would be so much fun.
That's right. Good. Yeah. All right. Well, Paul, Happy New Year.
Happy New Year. Happy holidays. Enjoy the break, whatever it is.
All right. Sounds good. We'll see you guys back in 2021.
Thank you for listening to this episode. If you have any questions, I put our contact info down in the show notes. You can find out how to get into contact with either one of us. Thank you again for listening and have a happy holiday season. And we will be back again later next year with some new episodes in early 2021.